For the sake of time, Madam Speaker, I am tabling the information relating to the roadworthiness and certificate of fitness of the buses. Madam Speaker, I have to inform the House that operational and HR issues at Rivière-du-Rempart have been brought to my attention several times by my colleague as well. I have requested the NTC to probe into the matter at the earliest, now that we have a new general manager, 1 week ago, Dr. Arvind Sunaran, who knows the domain well because he's a mechanical engineer.
Thank you, Minister. Is that all right? Yes. Honourable Fourth Member for Port Louis North and Montaignon.
Yes, thank you, Madam Speaker. B741.
Madam Speaker, I thank the Honourable Member for this question. I wish to inform this House that the comprehensive process of constituting the boards of our public higher education institutions has been formally initiated and has progressed to a considerable advanced stage. I'm informed that the completion of this critical governance framework is imminent and shall be finalized within the immediate term. Madam Speaker, during this interim period, and in order to safeguard the uninterrupted operational efficacy and governance of these institutions of paramount importance to our educational landscape, the Permanent Secretary of my ministry has graciously undertaken to serve in the capacity of acting chairman for the University of Technology, Mauritius, Open University of Mauritius, while also providing administrative guidance and facilitation to all the other HEIs to ensure absolute continuity and strategic oversight in the operations of these institutions, thereby precluding most major disruptions to the essential functions and progressive development of these establishments. Moreover, in the aftermath of the last general election, I have established a calendar of regular management consultations with the heads of our higher education institutions. These systematic management meetings, which I chair personally, are conducted to ensure optimal coordination among all stakeholders to address expeditiously any operational considerations that may arise and to maintain the most exacting standards of international excellence throughout this transitional phase. Madam Speaker, I wish most emphatically to show this House that the formal establishment of these boards remain an absolute priority within my ministry's agenda. And I undertake to keep this House fully apprised of all substantive development as they unfold.
Thank you, Minister. Yes? Yes?
Madam Speaker, as the Minister is aware, he cannot, neither him or the Permanent Secretary,
Question.
it is a question, substitute themselves to the councils, to the statutory legislations that which regulates the University of Mauritius, the University Technology of Mauritius, the Open University, and University of Mascareignes. Therefore, can the Minister say, with regard to the decisions taken by all these institutions to date, since 8 months, whether it is in terms of recruitment and other administrative functions, have these decisions to date been overtaken by him or his permanent secretary, or have they been left on autopilot?
I can assure the member that there has been no recruitment on permanent basis during this month.
My second question. That is precisely my point, Madam Speaker. In fact, there is, for example, at the University of Mauritius, for the medical department, there is a lack of trained doctors who come.
Question, please.
Is the Minister aware that there is a dire need of decisions to be taken by this council as their statutory
That's good. That's
framework provide, and that since 8 months, as he has admitted himself, they are paralyzed? Is that acceptable to the taxpayer?
Let me tell the honourable member, for the first time, we have doubled the number of students following medical courses at University of Mauritius, and the programs are running well. The program depends on a number of professionals working part-time in our hospitals and both public and private. So I can assure the member I'm fully aware and the situation is under control.
Last.
That is precisely, Madam Speaker,
Good,
because
make statements.
of operational capacity now being, because of the number of students that have increased, why the operational capacity has been fully stretched out and needs a council to appoint new personnel.
The Honourable Member has taken the example of medicine, where we need both people who are practicing. So we depend a lot on part-time tutors that the universities can recruit under their own regulation because they are not full-time. So I can assure the member that the universities are allowed to take professionals who are practicing because they need to teach our students about the practical skills. And this is being done.
Okay, next question. Give me time now to find where I am. There's one question which has already been replied. That is question B742. That we have already had. So now we move on to, I can't hear. The Honourable Second Member for Kalti-Miltiamuka, Dr. Tani.
Thank you, Madam Speaker. Question B743, please.
Madam Speaker, I am informed by the Conservatoire National de Musique François Mitterrand that the part-time music teachers do not receive any salary, but are instead remunerated based on the number of hours that they have worked during a month. As per my information, they have received their remuneration up to June 2025. However, the compensation component based on actual hours worked has not been paid since March 2025. This delay has been attributed to the payroll software license not being renewed on time by the Conservatoire, leading to its expiry at the end of February 2025. Consequently, all calculations are being done manually, which has significantly slowed down the process. Madam Speaker, it is unfortunate that I have come to learn of this matter only through the present parliamentary question. I do not accept that staff should be penalized due to poor planning by the Conservatoire's management. With only 46 part-time music teachers and adequate administrative staff in place, such computations could and should have been done using basic tools like Excel spreadsheets. The delay is therefore unjustified. I have given clear instruction that all outstanding compensation, including arrears, must be paid in full by the end of this month. At the same time, the Conservatoire has been directed to initiate procurement exercise for the renewal of its payroll software without further delay. Additionally, I have requested an internal investigation to determine the reasons behind this situation. Where necessary, appropriate action will be taken to ensure that similar lapses do not occur in the future. Madam Speaker, I will not tolerate administrative efficiency that delays fair and timely payment to employees. We remain committed to upholding transparency, accountability, and good governance across all public institutions. Thank you.
Thank you. Yes, Ms. Tanu, it's all right. Okay, so now I have the Honourable Third Member for Montagne Blanche and Grand River South East. Dr. Shantali.
Thank you. B744.
Madam Speaker, the new eligibility criteria for legal aid and legal assistance, as provided for in the Act passed by this House on the 8th of July, are in furtherance of this government's aim to facilitate access to justice in all districts of Mauritius, including Rodrigues. They participate towards the fulfillment of the provisions to the secure protection of the law for all, a right enshrined in Section 10 of our Constitution. The honourable member is therefore right to highlight, as others have done during the debates on this legislation, the need for a wide dissemination of the relevant information to members of the public. May I remind the honourable member that the Act imposes an obligation on the court to inform a person in a language that he is conversant with of the possibility to obtain legal aid, and at the station for a police officer who intends to record the statement of a person under warning to inform that person, in case the person is not represented by counsel, that he may make an application for legal assistance, for legal advice and counselling during the recording of the statement. A resident of constituency number 10 will therefore benefit from this when appearing before the district courts, whether at FLAC or elsewhere, or before the High Courts in Port-Louis. The legal duty being that of the court, it will be fulfilled by none other than the learned magistrate presiding over the case or the judge, as the case may be. However, I do agree that local information campaigns could be useful to reach citizens even before they get inside a courtroom or a police station. I will therefore liaise with the Chief Justice, the Master and Registrar, and the Government Information Service to look into the possibility of launching a campaign which would include having clear and instructive posters put up in public places such as post offices, community centres, court buildings, as well as publications in the press and on social media.
Thank you, Attorney General. Yes, next question. The Honourable Second Member for Grand Bay, Poudre d'Or, Mr. Bijan.
Thank you, Madam Speaker. B745.
Thank you, Madam Speaker. I wish to inform the House of the Beach Authority is presently working on a project for the upgrading of La Cuvette Public Beach, which is one of the most popular beaches in the north. Pending the implementation of the above, reinstatement works will be carried out with regard to footpath, road marking, traffic signs, street lighting, and other amenities. Any suggestion from the honourable member is most welcome.
Yes.
Thank you, Madam Speaker. Can the Honourable Minister inform the House whether additional parking facilities will be expanded to accommodate the increasing number of visitors at La Cuvette Grand Bay Public Beach? Thank you.
This also is being taken into consideration. I think we'll have a very short, near future site visit with all the MPs.
Yes. Okay, great. The Honourable First Member for Piton Rivière du Rempart, Dr. Praya.
Thank you, Madam Speaker. B746, please.
Madam Speaker, I wish to inform the House that up to the year 2000, all foreign patients, including tourists, foreign students, foreign workers and other non-citizen visitors or residents seeking treatment or undergoing medical investigations in our public health institutions were required to pay for their treatments. In March 2001, a policy decision was taken to exempt foreign nationals holding a valid work permit from the payment of inpatient treatment fees in our health institutions. In 2020, the Ministry proposed a waiving of treatment fees for foreign nationals who are married to Mauritian citizens and hold a valid residence permit. However, this proposal was deferred by the then government. Madam Speaker, I am pleased to inform the House that with effect from March 2025, the Ministry's current policy provides for exemption of treatment fees for foreign nationals married to Mauritian citizens. This exemption applies to treatment received at public hospitals and healthcare facilities, subject to the production of relevant documentary evidence, such as marriage certificate and proof of residence. Furthermore, foreigners holding a valid work permit or occupational permit continue to benefit from exemption from treatment fees under the same policy. There have been instances where foreign patients have sought treatment at regional hospitals without the financial means to cover the cost. on humanitarian grounds and in line with the principles of universal access to health care, such patients have not been denied treatment. Accordingly, there have been several cases in which medical care has been provided to these individuals free of charge. Madam Speaker, with regard to outstanding payments owed by expatriates and foreign nationals for treatment received by public health care institutions, I am informed that the total outstanding amount for inpatients currently stands at 360,970 rupees for 5 patients. Madam Speaker, I wish to further inform the House that hospitals are actively following up with patients to recover outstanding fees. In cases where patients are facing financial difficulties, payment facilities are granted, allowing them to settle the treatment fees in installments.
Thank you. Yes, Dr. Umir.
Thank you. In view of this current government interest in making that healthcare is available to all, may I ask the Honourable Minister whether his ministry would recommend the use of visual display units in each different hospital that would depict the services that are provided to expat, which services, again, type of payment, which services will be free, such as in emergency cases, and thirdly, as you rightly said, there are now some who have been exempted, and that at least for any expatriate who goes to our public hospital, they know beforehand what is awaiting them in terms of payment. Thank you.
Okay. Well, I look into the suggestion made by the honourable member.
Yes, sounds reasonable. Yes, thank you. Now we have the Honourable Fourth Member for Rodrigues, Mr. Edouard.
Thank you, Madam Speaker. B747, please.
Good.
Madam Speaker, I thank the honourable member for this question. I'm informed that there are 716 students from Rodrigues are currently pursuing their academic endeavours across diverse range of courses offered within our public higher education institutions. It is important to note that since the inception of my ministry, we have received no formal representation concerning any difficulties experienced by our Rodriguan scholars in their educational pursuits. I also wish to highlight that students from Rodrigues who are enrolled in undergraduate programs derive full benefit from free tertiary education scheme. Indeed, it bears emphasis that all students who hold citizenship of the Republic of Mauritius are afforded precisely the same educational facilities and opportunities without distinction. Furthermore, I'm advised that the University of Mauritius maintains a specialized student financial assistance fund expressly designed to provide support to students from economically disadvantaged backgrounds in Rodrigues. Madam Speaker, in our endeavor to enhance accessibility and remove administrative impediments, we have instituted comprehensive digital platforms for course registration, delivery, fee settlement, thereby obviating the necessity for superfluous travel. Most notably, students may now submit their requisite document directly to the Commission for Vocational Training in Rodrigues for the purposes of University of Mauritius registration. Concurrently, our higher education institution maintains a systematic program of deploying academic and non-academic personnel to Rodrigues to deliver crucial face-to-face instruction, as well as to conduct assessment and exams, thereby ensuring that program integrity and academic excellence are uncompromisingly maintained. Madam Speaker, with respect to physical infrastructure, I'm informed that Polytechnics Mauritius Limited presently maintains 2 operational campuses in Rodrigues, situated at Baie Malgache and Mont-Lubin respectively. Of particular significance, PML has formulated a comprehensive extension project for Rodrigues Baie Malgache campus, which currently awaits deliberation by the appropriate commission within the Rodrigues Regional Assembly. This strategic expansion shall furnish 4 supplementary teaching facilities, thereby substantially augmenting our capacity to deliver an expanded curriculum and accommodate a greater number of students. I wish to reaffirm this government's steadfast and unequivocal commitment to providing inclusive educational opportunities for every citizen of our Republic. This commitment necessarily encompasses our aspiration to establish a consolidated campus facility capable of serving multiple educational institutions contingent upon the availability of the requisite financial resources. The academic aspirations and intellectual advancement of the Rodrigues youth constitute matters of supreme importance to this administration, and all future policy formulation shall be informed by our abiding principles of national unity and our unwavering dedication to ensuring equitable access to educational excellence for all our citizens. I should be most grateful if the honourable member would favour my ministry with any suggestion and observation that might serve to further enhance the academic experience of our esteemed Rodrigues students within our public higher education system.
Thank you, Minister. Yes, Mr. Edouard.
Thank you, Madam Speaker. I thank the Honourable Minister for his reply. Will the Honourable Minister consider the difficulties faced by the students, Rodrigues students in Mauritius, in relation to lodging, which is very expensive here? How the Ministry can help, please? Thank you.
Yes, I would be most willing to even meet them and discuss the issue further.
Thank you. Yes. Honourable Third Member for Bobassa Petite Rivière.
748, please.
Madam Speaker, the employment of foreign workers under a work permit is governed by the Non-Citizen Employment Restriction Act. The Act makes provision, among others, for guidelines which sets out the step to be taken by the applicant and the documents to be provided when applying for a work permit. Application for work permit in respect of foreign workers, including foreign football players, must be submitted via the National E-Licensing System, NELS, of the Economic Development Board. At the time of application, the club should submit a covering letter from the relevant club specifying the player's accommodation details, domestic transfer certificate or an international transfer certificate as the case may be, a recent cash flow statement from the applicant for the specified season, a no objection letter from the Mauritius Football Association indicating the season during which the player will participate and the name of the receiving club, additional supporting documents such as the club's certificate of association, a passport-size photograph of the player, a copy of the player's valid passport, provisional medical clearance, valid for 6 months, and a vetted employment contract, and a no objection letter from the previous employer for interclub transfer. Madam Speaker, work permit for foreign players are issued for 1 season at a time and may be renewed for an additional season subject to the approval of the residence permit by the Prime Minister's office. Players must be aged between 18 and 60 years. The general conditions attached to the employment of non-citizens, including foreign players, are as follows. A work permit is issued to a particular non-citizen and the work permit is not transferable. The non-citizen is not permitted to seek or accept alternative employment while in Mauritius or to engage in any trade, art or gainful occupation. The permit should be kept by the holder and produced to any authorized person on demand or within 3 days after demand at such police station as may be specified by the authorized person at the time of the demand. And finally, the permit may be varied or cancelled at any time. Madam Speaker, I am informed by the Ministry of Youth and Sport that the present policy is to allow football clubs to recruit up to 3 foreign players for the Super League and up to 2 foreign players for the National First Division League. Moreover, in order to ensure quality players, the Ministry of Youth and Sport has requested the National Sports Federation to include in their internal rules that local clubs would only be allowed to recruit foreign players who have played at the highest national division of their country of origin for the last 2 years.
Yes, question, yes.
À son niveau, l'honorable ministre a-t-il reçu des représentations officielles de la Mauritius Football Association en vue d'augmenter le quota de joueurs étrangers par club de 3 à 5? Si oui, quelles sont les raisons qui ont été avancées par la MFA par rapport à cette demande?
Madam Speaker, I'm not aware of the request to increase the number of footballers from the MFA, but it will be directed to the Ministry of Youth and Sport, and my ministry we will stand guided by whatever policies taken at the level of the Ministry of Youth and Sport.
Yes. Oui, allez-y.
Le ministre peut-il informer la Chambre des mesures mises en place pour s'assurer que les règlements ne soient pas contournés, notamment dans les cas où un joueur professionnel est recruté alors qu'il est initialement entré à Maurice sous le statut de travailleur?
Yes, Madam Speaker, the honourable member should know that work permit is issued by my ministry, but residence permit is issued by the Prime Minister's office. So very often, when a foreign worker comes in Mauritius on a visa, on a tourist visa,
yes,
he is not allowed to then apply for a work permit. The Prime Minister's office will object to it. So in the case that the honourable member has mentioned, probably the Prime Minister's office will object to a work permit being issued to the foreign football player.
Okay, next question. The Honourable Second Member for Rodrigues.
Yes, thank you. B/1749.
Madam Speaker, the Rodrigues Commission for Health operates under the umbrella of Rodrigues Regional Assembly and is a primary governing body for health services in Rodrigues. The Commission for Health collaborates with my ministry but maintains its distinct operational structure within the Rodrigues Regional Assembly. My ministry provides support and collaborates with the Commission on specific health projects in Rodrigues. Madam Speaker, I wish to inform the House that a delegation headed by the Commissioner for Health and others was in Mauritius in May 2025. Following discussions, it was proposed to assess the strengths and weaknesses of the health services in Rodrigues. Subsequently, a team comprising of the Director of Health Services, the biomedical engineer, and the senior healthcare technologists of my ministry proceeded to Rodrigues from 9th to 14th June 2025 to carry out an analysis of the major medical equipment in various departments, including the medical laboratory at Queen Elizabeth Hospital. Following the evaluation of the medical equipment, including respiratory devices and anesthesia workstations in Rodrigues, various shortcomings have been identified as follows. A. Healthcare technologists have not been recruited to cater for life support and critical equipment. This is a very serious shortcoming. B. Preventive maintenance has not been carried out in a systematic manner. C. 6 ICU ventilators were lying idle at Mont Lubin Isolation Center. And 4. D. Unused equipment is stored in poor environmental conditions that may lead to unnecessary breakdown. The report also provides a number of recommendations with a view to implementing good practices in the utilization of these machines so as to minimize the risk of unnecessary breakdown and causing disruption of essential services. Madam Speaker, I am further informed that pursuant to an invitation by the Commission of Rodrigues for Health, a high-level dialysis capacity assessment mission was conducted by the National Dialysis Coordinator in Rodrigues from 19th to 23rd June 2025 to evaluate the current status and future needs of renal care services. This mission provided a strategic platform to assess service delivery and identify areas for improvement at the Rodrigues Dialysis Unit at Queen Elizabeth Hospital in care. Madam Speaker, my ministry acts promptly whenever a weakness in the health services is reported. Now, as regard carrying out a full medical health audit in Rodrigues is concerned, this will require time and expert resources. I therefore propose to approach the World Health Organization and request the services of an expert to carry out the full medical health audit in Rodrigues. Madam Speaker, notwithstanding the above proposal, I wish to reassure the Honourable Member that my Ministry will continue to provide assistance to the Commission for Health for the referrals of patients from Rodrigues to Mauritius for comprehensive treatment and care, capacity building of medical and paramedical staff, sensitization of the population on various public health issues and non-communicable diseases, evaluation on the accessibility and quality of health services, state-of-the-art equipment, modern infrastructure, amongst others. Madam Speaker, in this context, a multidisciplinary team will be set up to collaborate with the Rodrigues Regional Assembly so as to achieving improved health security, better service delivery, and enhanced patient outcomes aligned with the principles of universal health coverage. And I propose to lead the high-powered level delegation to Rodrigues in the coming months to look into these aspects.
Thank you, Minister. Yes. Don't comment.
No
Question.
comments.
Question.
I was going to comment.
No, then you sit down. I'm sorry. I'm saying it very nicely. Very nicely, I'm saying. Okay? We are not here to comment. The Honourable Second Member for Savannah Black River.
Madam Speaker, please. B750, please.
Madam Speaker, I am informed by the NLTA that 53 new road service licenses were allocated during the period 2014 to 2024. Same includes 4 road service licenses and 49 temporary road service licenses. The 3 road service licenses were allocated to UBS and 4 to RST, Rosil Transport, in 2022. As such, no additional disbursement was made to these two bus companies in respect of the 7 road service licenses with regard to free travel compensation and other subsidies. Out of the remaining 46 licenses allocated to the individual bus operators, a total of 44 RSLs were effectively implemented, and subsequently these operators have benefited from free travel compensation and other subsidies, namely diesel subsidies and other financial support, which includes interim allowance. According to information obtained from the NLTA, Madam Speaker, a total sum of 72.5 million rupees was disbursed for all the 44 newly implemented RSFs. As regard to the last part of the question, I wish to inform the House that the NLTA has already been requested to carry out a holistic survey to determine, among others, as to whether there is still need to maintain the existing temporary road service licenses. Subsequently, a decision will be taken. Thank you.
Yes, yes, yes. Go ahead.
Madam Speaker, please. As mentioned in the previous PQ, the Honourable Minister informed the House that an inquiry will be set up according to the 49 RSL issue. Whether the inquiry has been set up, if yes, where matters stand?
Right. There is now a new management at the NLTA, and they are looking at it afresh. At that time, there was a previous management which were implied in this sort state of affairs. So in due time, we will come to the House with the conclusion of the findings.
Thank you. Honourable Third Member for Port Louis North and North Island.
Thank you. B751, please.
Madam Speaker, the Road Traffic Act was amended in 2019 by Act 24 of 2019 so as to facilitate payment of fixed penalties. Accordingly, a new section 192 subsection 3 of the Road Traffic Act makes provision for a person who has been served with a fixed penalty notice to electronically pay the fine from the date of the offence. However, I wish to inform the House that the amendments brought to the Road Traffic Act in 2019 have not yet been proclaimed and therefore are not in force. I'm informed by the Master and Registrar of the Supreme Court that the system at the judiciary is ready to accept online payment for fixed penalty notices through the Supreme Court portal using e-payment facilities such as credit cards, debit cards, MoCAS QR code, and account transfer. Once the 2019 amendments are proclaimed, online payment for fixed penalty notices will therefore be activated. Madam Speaker, I therefore propose to liaise with the Minister for Land Transport so that the necessary be made to proclaim the relevant provisions of the Road Traffic Amendment Act number 3 of 2019 and to consider any further amendments to the Road Traffic Act so as to extend online payments by a person who has been served with a photographic enforcement device notice, that is, speed cameras.
Yes? Okay, good. The Honourable First Member for Lacave and Phoenix.
Thank you, Madam Speaker. B752.
Your previous question will be given by written reply.
Thank you.
Now you have a chance to have a go at it. Thank you. Okay, B752.
Thank you very much, Madam Speaker. Madam Speaker, with your permission, I shall reply to the question put by Honourable First Member for Lacave and Phoenix. An island-wide survey was carried out in 2009, and around 237 sites were identified and listed as wetlands. Now, the list was reviewed in 2018 using remote sensing technology, where some 1,000 areas were listed as potentially being wetlands. Presently, consultancy is ongoing at the level of the Ministry of Environment, Solid Waste Management and Climate Change, in collaboration with the National Park and Conservation Service to establish the listed sites. In addition, following the enactment of the Environment Act 2024, coastal freshwater marshlands and upland marshlands, which are wetlands, were identified as environmentally sensitive areas, which require an environmental impact assessment license prior to any development thereafter. Madam Speaker, the National Park and Conservation Service is responsible for the implementation of the Ramsar Convention, which includes the management, preservation, and protection of wetlands across Mauritius and preservation of the rich biodiversity located thereat. The National Park and Conservation Service has also been entrusted with the responsibility as the enforcement agency following the enactment of the Environment Act of 2024. Also, a National Ramsar Committee was set up in January 2004 at the level of the Ministry to assist in the implementation of the Ramsar Convention. The National Ramsar Committee is also responsible for monitoring and protection of wetlands through conditions attached to building and land use permits, wherever a wetland is present or is in the vicinity of any development. In fact, since 2006, no development on wetlands and the 30-meter buffer zone is allowed. Madam Speaker, concerning Part B of the enactment of the Environment Act 2024, I am informed that a total of 36 cases pertaining to encroachment, illegal construction, and backfilling done on wetlands have been reported to the Ministry of Agro-Industry, Fisheries, Food Security, and Blue Economy. And 54 such cases have been recorded at the level of the National Park and Conservation Service over the last 5 years. Furthermore, I'm informed that 3 stop orders have been issued by the Ministry of Environment, Solid Waste Management and Climate Change for stopping such illegal activities and ordering the contraveners to restore the wetland area to its original site. Madam Speaker, wetlands with a rich biodiversity form part of the natural capital, and each reported case of encroachment, illegal construction, and backfilling is one too many. To further reinforce the protection of wetland, the government agreed in May this year to the drafting of a wetland bill and wetlands regulation which would be dedicated for the protection, management, restoration and enforcement measure for the preservation of all wetlands across the Republic of Mauritius. Through the enactment of this legislation, a new impetus will be given to the long-term sustainability of wetlands.
Thank you, Minister. Are you all right? Yes. The Honourable Second Member for Belle-Rose-Quatre-Bornes.
Je vous remercie, Madame la Présidente. B753. Merci.
Heureusement que le ministre sait courir.
Thank you. So, yeah, so it was an urgent matter regarding a cabinet paper. Thank you.
I'm sure it was urgent.
Madam Speaker, the Motor Vehicle Insurance Arbitration Committee, MVAC, has been established under the Road Traffic Act to determine disputes arising between two insurers or between a policyholder and an insurer regarding their respective liability on the amount of compensation to be paid following a road accident not involving bodily injuries. The MVAC usually sits in 4 divisions, where each division is presided by the chairperson or a vice chairperson. From 2019 to 2024, a total number of 4,776 cases were lodged at the MVAC, out of which 2,819 cases were determined. That is, a ruling was issued or the case was set aside. Furthermore, for 322 cases, the MVAC is still awaiting clarification for the cases to be determined. It is to be noted, Madam Speaker, that for the same period, 1,635 cases have remained unattended by the previous chairperson and the 3 vice chairpersons. However, I can reassure the House that the MVAC has been reconstituted since April this year, and the new team has been requested to mop up this huge backlog.
Yes.
Je vous remercie, Madame la Présidente. Would the Minister inform the House whether the situation involving over 1,000, no, you said exactly 1,635 cases has caused hardship to the victims concerned?
Certainly, because this is the last recourse that they can have, because the MVAC is like some sort of a tribunal. So if the cases are not determined, the cases still, people face hardship. To reply to your question, people face hardship, yes.
Yes.
Thank you, Madam Speaker. Can we know who is the chairperson of the Motor Vehicle Insurance Arbitration Committee? Thank you.
You mean the previous, the person between that period in time? It was Mr. Dode, one Mr. Dode. Yeah. Didier Dode? Yeah. Mr. Dode.
With a D. With a D.
Yes, correct.
Okay.
I can look for his name in the file, but I do recall it's Mr. Dode.
Okay. The Honourable First Member for Saban Black River, Mr. Babaji.
B754.
Thank you, Madam Speaker. I'm informed that as at March 2025, there were 52 cases of residential squatting on state land at Cotorafin and 4 cases at Calyptus, Cas-Noyal. In 2015, the then Ministry of Housing and Lands decided to regularize as far as possible all pre-July 2015 residential squatters. In regards to Cotorafin, the cases of 39 out of 41 pre-July 2015 were regularized in situ in 2017, whilst necessary documents are yet to be submitted by the 2 remaining families to enable regularization. My ministry has already made a request to the CEB and the CWA for proper provision of electricity and water supply for these 39 families. An amount of 47 million has been provided in the budget estimates of 2025-2026 of my ministry for the provision of electricity and water supply to 4 regions, including Cotorafin. I am, however, informed that the CEB and CWA are facing serious challenges to provide the utilities to the families concerned due to lack of proper access, road access. My ministry is coordinating with all relevant authorities with a view to facilitating both the CEB and the CWA. Madam Speaker, in regards to Carocaliptus Cas Noyal, I am also informed that following the regularization in situ of 39 cases of residential squatting in 2013, there remains 4 cases of residential squatting which needs to be addressed. 2 cases concern pre-2015 squatters that can only be regularized after existing encroachments issues are sorted out. Insofar as the post-2015 residential squatters, because it keeps coming pre and post, my ministry is working on recommendations that I propose to submit to government in due course. However, members will appreciate that addressing the issue of squatters on state land is indeed a complex one, due to different types of constraints such as encroachment, sites being found on river reserves, wetland, nature parks, public beaches, topography of lands, flood-prone areas, amongst others. For example, in Kotorafa, I am informed that 8 out of the 52 post-July 2015 squatters are found on Comtesse de la Marque public beach, and most of the remaining 44 cases are found either within 30 meters of the high water mark or on marshy lands, rendering their regularization in situ impossible. And Madam Speaker, let me conclude by saying that is some of the consequence of a Member of Parliament, the then Member of Parliament and Minister of that constituency, going to promise land to everyone in order to have votes in return. And this is what you have as a result, telling people to go and take plots of land, go vote for me, and in return I'll get you the lease. But not knowing and not even observing where they are going to take the land. Some of them are ended up on the public beach, some ended up on marshland, and less than 30 meters from the high water mark. Thank you.
Thank you, Minister. Yes?
Will the minister consider of improving the road access over there to make it public road, as some people over there are sick and ambulance can't get access to it?
As I said, we are working with all other relevant agencies, ministries, in order to find solutions. Now, obviously, with regards to road access, I will have to speak to the relevant authorities. That would be either the local authority or any other relevant department that will be able to find the solution and the budget in order to build the roads. So yes, it is an urgent matter, but the other matter is that there are other people who have registered with the NHDC and who are patiently waiting for houses, as opposed to squatters who come to land, do not register for NHDC houses, and expect to have electricity, water, land given by the state and paid by the state. I know there's an urgency in order to give them houses, but we have to be able to balance things as it should. Resources have to be used efficiently and reasonably, and not simply being obtained simply by the asking. Thank you.
Thank you, Minister. Yes, now we have the Honourable Third Member for Port-Louis North and Montaillon, Mr. Cazel.
B755, please.
Madam Speaker, the Abercrombie Market Fair project stands as a textbook case of administrative failure and poor decision-making by the previous government. Despite being initiated in year 2019, the project faced repeated delays and technical disputes between the consultant and the contractor. Matters escalated when the contractor erected a structure without formal approval, and structural deficiency were later identified issues that could have been avoided with proper oversight. Instead of resolving the matter professionally, the former government hastily terminated the contract in May 2023. Based on legal advice from Counsel Rubina Jadu John Bokas and Senior Counsel Ravin Chetty, and with the endorsement of the then Prime Minister, Dr. Hosnu, Minister of Energy, Mr. Joe Lejongo, and Minister of National Infrastructure, Mr. Riam, this termination was done without valid cause. Madam Speaker, as a direct consequence of that decision, the contractor initiated an arbitration proceeding. The award of the arbitration tribunal was delivered on 9 May 2025 and was in favor of the contractor. The tribunal orders the Municipal City Council of Port-Louis to pay an amount of 25,386,061 rupees to the contractor. However, following the retention of an escrow amount and the deduction of tax deduction at source, the council had to disburse an amount of 21,257,112 rupees and 33 cents to the contractor. After nearly 6 years, Madam Speaker, only 21% of the works have been completed, and the people of Port-Louis are left to bear the cost of this grave misjudgment. Madam Speaker, in view of the complexity and gravity of the matter, I am tabling the following documents for the benefit of the Honourable Member. A copy of the arbitration award, the name of the arbitrator and parties involved, full timeline and status of the project, details of the procurement and contract termination, legal opinions received from Council Rubina Jadu, John Bocas, and Senior Council Favinchetti, records of the meeting chaired by the then Lord Mayor and attended by former ministers, financial clearance from the Ministry of Finance, and all supporting documents justifying the payment now being made. Madam Speaker, these documents clearly show how a poorly ended decision by the former administration taken without proper justification led to financial loss and stalled the development. Thank you.
Yes. All right. The Honourable Second Member for Belle-Rose-Quatre-Bonnes.
Je vous remercie, Madame la Présidente. B756. Merci.
Madam Speaker, I am informed by the Traffic Management and Road Safety Unit, TRMSU, that prior to the implementation of the Metro project, the public used to park their vehicles in the space fronting commercial complexes on both sides bordering Saint-Jean Road, between Saint-Jean Roundabout and Victoria Avenue. Same could accommodate approximately 190 vehicles with no dedicated parking zones. With the implementation of the Metro project, Metro Express project, in 2021, this lane configuration along Saint-Jean Road was significantly modified, resulting in substantial decrease in the number of parking to around 40, so from 190 to 40. I wish to point out that for proper management of the limited parking space, same had to be converted into paid parking. Furthermore, to address the lack of parking space along Saint-Jean Road, the TRMSU constructed 70 free public parking spaces on 5 plots of land along Saint-Jean Road, namely Tulip Road, Surat Avenue, Columbia Court, Lyell Avenue, and opposite the metro station. Madam Speaker, I am informed that the Municipal Council of Quatre-Bonnes has acquired 2 plots of land near Surat Avenue and Tulip Road to provide for 35 and 105 parkings respectively, whereby works are nearing completion. Moreover, with the upcoming proposed Quatre-Bonnes Urban Terminal project, additional parking facilities will be provided. Madam Speaker, I wish to highlight that given the whole stretch of the Saint-Jean Road from Victoria Avenue to its junction with Tulip Road is already built up on both sides, there is no further space to provide for additional parking facilities. Thank you.
Yes.
Je vous remercie, Madame la Présidente. Malgré les efforts du ministère, le problème de parking est persistant. Alors, can the Minister inform the House whether consideration will be given to implementing a smart parking as management system in this area? Thank you.
The Honourable Member is very technology savvy. So am I. So I think we are in the same wavelength. I can discuss with my colleagues.
Thank you, Minister. Yes, now the Honourable Third Member for Rodrigues, Madame Manon.
Excuse me.
No. Vous aviez encore une question. Attendez, oui, yes, of course. I'm sorry. I'm sorry. Okay, one more question for you, Miss Anctil.
Je vous remercie, Madame la Présidente. B 757.
Okay.
Madam Speaker, I'm informed that an alleged case of impersonation regarding an application form for excise duty concession submitted through the National Women's Council, NWC, was indeed reported to my ministry. Madam Speaker, the application for excise duty concession was submitted to the Customs Department by the NWC in the name of Mrs. NDJN, currently employed as manager since 2nd February 2021. The Customs Department issued the excise duty concession certificate on 28 April 2025. As it was not clear whether the manager was eligible for the excise duty concession on a motor vehicle on ground of her years of service, on 21st June 2025, my ministry requested the Customs Department to cancel the excise duty concession certificate issued to Mrs. NDJN. The certificate was subsequently cancelled by the Customs Department on the same day. As per normal procedure, Part B of the application form for the excise duty concession should have been filled in and signed by the head of my ministry. However, this part of the form was signed by the HR officer, Senior Human Resource Officer of National Women's Council on 28 April 2025 without the approval of my ministry. Considering the issue to be a case of impersonation, the matter has been referred to the police on 30th May 2025, the Central Crime Investigation Department, the CCID, and the Financial Crimes Commission, FCC, on 18th June 2025. The case is still under investigation.
Yes.
Just one.
Of course.
Je vous remercie, Madame la Présidente. Choquant. Will the Minister indicate whether Madame Jagnat Naik, the manager of the National Women's Council, has been informed of the alleged fraud involving her application form for an excise duty concession? Thank you.
Yes, Madam.
Yes. Now it's the time for Miss Manon. Second time that I'm missing you. Go ahead.
Thank you, Madam Speaker. B758.
Madam Speaker, I'm informed that in accordance with the scheme of service for the post of midwife, same is filled either by appointment of student midwife who are fully registered as midwives with the Nursing Council in accordance with legislation in force in Mauritius, or B, by selection from among candidates who are fully registered as midwife with the Nursing Council in accordance with legislation in force in Mauritius. In Mauritius, presently there are 157 funded posts of midwife available in public health institutions. 136 posts of midwife have already been filled, while there are 21 vacant posts of midwife. In addition, 17 trainee midwives who have already passed the final examinations have been recommended for appointment as midwife to the Public Service Commission on 26 January 2025. Meanwhile, 4 remaining trainee midwives have passed the final examinations in June 2025 and their appointments are being processed. Appointment to the grade of midwife is initiated as and when vacancies occur. In respect of Rodrigues, there are 26 funded posts of midwife, out of which 17 posts have already been filled. These posts are advised by Rodrigues National Assembly and recruitment is carried out by them. Madam Speaker, with regard to part A of the question, I'm informed that since 2014 to date, a total of 137 candidates have been recruited as trainee midwives in the public health institutions in Mauritius as follows. 2015, 5, 16, 62, 17, 11, 2019, 28, 2028, 2021, 1, 2022, 22, total of 137. 103 have already been appointed as midwife. Out of the 34 remaining, 24 are being appointed as midwife, while 13 have left the grade of trainee midwife. As regards Rodrigues, I'm informed that 8 candidates have been recruited as midwife over the last 10 years. Regarding Part B of the question, I'm informed that 42 of the midwives in Mauritius have been promoted to the grade of senior midwife on shift as follows: 2019-20, 2028, 2022-12, 2024-2, a total of 42. For Rodrigues, I am apprised that none has been promoted to the grade of senior midwife, and the scheme for the senior midwife on shift has not yet been prescribed. That this matter has to be dealt at the level of Rodrigues Regional Assembly. The House may wish to note that midwives are promoted to the post of senior midwife on the basis of experience and merit, who reckon at least 5 years service in a substantive capacity in the grade of midwife. Madam Speaker, I am proposing to review the structure of the grade of midwifery to upgrade skills and competencies for improved service delivery.
Thank you, Minister. Yes. Okay, next question. Yes, Madam Manon, you're happy with that? Yes. The Honourable Second Member for Vieux-Grand-Port, Mr. Seaburn.
Thank you, Madam Speaker. It's question B/759, please.
Madam Speaker, with regard to Part A of the question, and according to records available at the Ministry, I wish to inform the House that for the period 2014 à 2024, the Mauritius Fire and Rescue Service gave its no objection to Marsico's landfill project subject to a number of conditions. I have been informed that all these conditions have been addressed except for the installation of a permanent pressurized pipeline. Madam Speaker, I am informed that provision was made for a pressurized firefighting pipeline in the new contract for the vertical expansion of a landfill awarded in June 2024 to the joint venture Sotravic Strata. The design for the pipeline, including intake works at a suitable location along the nearby Lachaux River, has been prepared by the landfill consultant, COWI Lux Consult, and already approved by the Mauritius Fire and Rescue Services. The construction of the pipeline is scheduled to start by end of November 2025. Madam Speaker, with regard to Part B of the question, a total amount of 2.977 billion rupees was disbursed for the various running contracts for the period 2014 to June 2024 to the joint venture Sotravic Enotech. Madam Speaker, concerning Part B1 of the question, I wish to inform the House that the period January 2014 to June 2024, no amount has been disbursed to the contractor for firefighting. However, further to a major fire outbreak of November 2024, the contractor joint venture Sotravic Strata has submitted a contractual claim amounting to 33.31 million rupees, out of which an amount of 23.18 million has been rejected, and the remaining still being assessed by the consultant. I have also been informed by the Mauritius Fire Rescue Service that the Mauritius Fire Rescue Service has submitted a claim to some 4.7 million rupees as expenditure incurred during the firefighting at the landfill in November 2024. Madam Speaker, regarding Part B2 of the question, I wish to inform the House that the landfill has an existing contingency plan aiming to mitigate and to combat fire outbreak at the landfill. And by this plan, the contractor is required to undertake, amongst others, the following: deploy a standby team with a water tanker on a 24-hour basis to extinguish any fire outbreak, call the Mauritius Rescue Fire Service to combat fire if required. 3, carry compaction of waste and cover with soil to prevent ingress of oxygen in affected areas. And 4, arrange to deploy other resources like excavators and water tankers should the need arise.
Thank you, Minister. Yes. Yeah. Okay. The Honourable Second Member for Savane Black River, Mr. Jarana.
Madam Speaker, please, B760.
Madam Speaker, the House may wish to note that in line with the coastal rehabilitation program, the services of the consultancy firm, namely Gus Consult, were enlisted by my ministry on 22nd May 2022 for a duration of 60 months to the tune of 94.6 million rupees for the design and supervision of coastal protection measures at 16 priority sites. The 16 priority sites include, amongst others, the Cascaved platform at Rivière des Galets. Based on the degree of erosion and the site specificity, the consultant has recommended the coastal protection and rehabilitation works were at to the tune of 20.1 million rupees, including of VAT. And also the following were: rock riverment of an approximate length of 110 meters along the river bank, reinstatement of existing concrete steps to allow safe access to the river, construction of wing walls for clearly demarcating the riverment and the steps, upgrading of existing areas, access to the site, and also provision of lighting facilities along the path and within the Kavedi platform area. Madam Speaker, the project requires an EIA impact assessment, an environmental impact assessment license, and consultations are currently ongoing with stakeholders for the finalization of the EIA. Upon completion of the EIA process, the consultant will be requested to prepare written documents, and a request for funds will accordingly be made to the Ministry of Finance.
Thank you. The Honourable Second Member for Quartier Militaire and Mokam, Dr. Tanu.
Thank you, Madam Speaker. Question B761, please.
Madam Speaker, the well-being of all our students remains a top priority for my ministry. In a world increasingly marked by emotional and psychological challenges, we have an increasing number of students who require support from psychologists. The National Education Counselling Service, operating under the purview of my ministry, continues to provide psychological and social support to those students who require such services. In regard to the primary and secondary state schools, I am informed that there are currently 39 educational psychologists providing services to students across the Republic of Mauritius. Psychological support is extended to students with the formal consent of parents or guardians to ensure that the latter are kept informed and are involved at every stage of the support process. With regard to paragraphs A, first and second part of the question, I am informed that each student requiring psychological support is entitled to as many sessions as deemed necessary, depending on the severity of the case and the outcome of the professional assessment conducted. And during the period January to June 2025, a total of 1,616 students were referred for the first time for psychological support services, and a total of 9,207 counseling sessions were carried out. With regard to part B of the question, I'm informed that an additional 42 educational psychologists would be required to ensure the timely and adequate provision of psychological support to all students in need. However, due to budgetary constraints, provision for their recruitment could not be considered during this present budget. In the meantime, to address the existing shortage, 22 educational social workers are providing essential support services through home visits, case interventions, parental guidance, and community outreach. Between January and June 2025, these officers have attended to 1,069 new cases and conducted 2,094 home visits. They also conduct sensitization sessions for students and parents on issues such as child protection, emotional well-being, discipline, and resilience. Thank you.
Thank you, Minister. Yes? Good. The Honourable Second Member for Grand Bay Poudre-d'Or, Mr. Bijan.
Thank you, Madam Speaker. B762.
Madam Speaker, I am informed by the NLTA that the daily operations of buses plying routes 21, 227, and 82, which operate from Belmont to Port Louis, are monitored by 10 regulators posted at Belmont Traffic Center. Trois checkpoint and Port Louis, the new transportation center. I'm made to understand that the main problems along these routes relate to the aging fleet, entailing frequent breakdowns and missed trips. According to figures provided by the NLTA, at least 10 buses are reported non-operational each day due to mechanical failures, especially among vehicles over 17 years old, and a persistent shortage of crew, including drivers and conductors. I wish to inform the House that the bus modernization scheme was revamped to cater for the purchase of high-flow buses, and bus operators are accordingly making necessary arrangements for the renewal of their fleet. That means they made application for support from government. As regards shortage of crew, my ministry is working closely with the Ministry of Labour and Industrial Relations to facilitate the recruitment of foreign labour. Madam Speaker, despite the constraints of acute shortage of staff, including at the level of the NLTA Inspectorate, the latter has continued to undertake monitoring and enforcement. With regards to Part B of the question, I'm apprised that 23 surprise checks have been conducted along routes 21, 227 and 82, whereby 29 contraventions have been established. I am tabling the dates on which surprise checks have been conducted. It is to be pointed out that these checks have been further reinforced since mid-June this year with the enlistment of 13 management support officers who are providing assistance to the NLTA Inspectorate pending the recruitment of road transport inspectors. Thank you.
Thank you, Minister. Yes, Mr. Francois.
B673. Madam Speaker, I'm informed by the Mauritius Institute of Education, MIE, that the Bachelor of Education in Technical and Vocational Education and Training, B.Ed Honours Program, was developed at the request of the Mauritius Institute of Training and Development, MITD, to strengthen the pedagogical competencies of its instructors, including those based in Rodrigues. The program has been accredited by the Higher Education Commission, HEC, on 29th May 2025 and has been advertised on 14th July 2025 in Mauritius and for Rodrigues. The MITD had already informed the concerned instructors about the course on 2nd December 2024. I'm also informed that the modalities for the implementation of the program are being worked out, and it would be designed in such a way so as to ensure the optimum use of resources and facilitate the efficient and effective delivery of training courses to all interested candidates possessing the required qualifications, including those from Rodrigues. The course will be run in a hybrid mode in Rodrigues with a combination of online and face-to-face sessions facilitated by resource persons from the MIE. Madam Speaker, as for the diploma in special education needs, I'm informed by the MIE that the intake for the July-August 2025 has not been advertised in Rodrigues, as the first cohort from Rodrigues is currently following the certificate course, which will only be completed in December of this year. Upon completion of the certificate course, the diploma course will be advertised thereat, and those who have been awarded the certificate will be eligible to apply. Thank you.
Thank you. Yes. Okay. Then the Honourable Second Member for Vieux-Grand-Port and Rosemary. Yes.
Thank you, Madam Speaker. It's question B/764, please.
Madam Speaker, at the outset, I wish to inform the Honourable Member and the House that this reply will be relatively lengthy, as it pertains to 4 different football grounds under the jurisdiction of the District Council of Grand-Port. The Honourable Member has requested detailed information regarding the history, current status, delays, and future plan for lighting installation at the Rivière des Créoles, Bois des Amourettes, Grand Sable, et Bambou Vieilleux football grounds. Madam Speaker, I am informed that since 2017, funds were allocated annually for the implementation of various capital projects by the District Council of Grand-Port, including the upgrading of infrastructure and installation of lighting facilities. However, it is regrettable that the Council, under the previous administration, did not consider the installation of lighting facilities at the Rivière des Créoles football ground as a priority, despite the fact that this ground has existed for over 50 years and covers an area of approximately 5,500 meters square. I am further informed that lighting facilities have never been provided at the Rivière des Créoles, Grand Stab, and Bois des Amourets football grounds. It is only recently, under the current government, that the District Council has submitted proposals for lighting works in the budget for the financial year 2025-2026. As regards the Rivière des Créoles football ground, I am informed that while bleachers and shelter were constructed in the year 2014 at a cost of 377,400 rupees, and upgrading and fencing work were undertaken in the same year at 89,239 rupees, no lighting facilities were ever installed. The current proposal estimates the cost for lighting installation is at 4 million rupees. Regarding Bois des Amourets football ground, the site has been in existence for more than 40 years. Turfing and fencing works were initiated by the National Development Unit, that is the NDU, in 2022, but remain incomplete. The football ground has not yet been handed over to the Council. The proposed lighting project, also estimated at 4 million rupees, has been listed under the proposed amenities project for financial year 2025-2026, subject to availability of funds. Similarly to Grand Stab football ground, in existence of over 30 years and covering an area of 6,000 meters square, remains without lighting to date. In 2015, the Ministry of Local Government allocated 138,000 rupees for the removal of damaged fencing, but no follow-up project was implemented. Also, the NDU had proposed boundary wall upgrading since 2014. Actual inclusion in the program occurred only in 2016-2017. Again, the lighting project proposed in the year 2025-2026 budget is estimated at 4 million rupees. Madam Speaker, with respect to the Bambou-Veilleuse football ground, which has been in existence for over 40 years, I am informed that the lanterns were previously installed by routing electrical cables through PVC pipes and affixing them directly on the fencing poles. However, all lighting facilities collapsed during the passage of Cyclone Batsirai in 2022, and to date, no remedial action has been undertaken by the District Council of Grand Port. The size of the plot is approximately 8,900 meters square, and the cost for new lighting works has similarly been proposed at 4 million rupees in the year 2025-2026 budget. I wish to inform the House that my ministry will formally write to the National Development Unit to request that the implementation of lighting facilities at Rivière des Créoles and Bois des Amourets be treated as a matter of priority under the proposed amenities projects, subject to budget availability. Additionally, the implementation of lighting works at Bambou-Veilleuse and Grand Stab will be considered under a suitable vote item by my ministry in the forthcoming budget planning. Madam Speaker, at a meeting held on 16 July 2025, I directed all chief executive and local authorities to ensure that all public infrastructure and assets are regularly inspected and properly maintained. It is a statutory duty to carry out regular inspection and take appropriate action where deficiencies are found. Thank you.
Minister. Everybody's happy. Good. I've got less than 10 minutes left. So now I'm calling the Honourable First Member for Piton and Rivière-du-Rempart.
Thank you, Madam Speaker. Question 765, please.
Madam Speaker, as from this year, there will be no modular assessments for pupils of grade 5. In line with the annual program for the PaySAC assessment 2025, students who are in grade 5 and have completed 5 years of schooling, inclusive of grades 1 to 5, and who are attending government, aided or registered primary schools may exceptionally sit for the PaySAC assessment in 2025, subject to requests made by their parents. However, those students who are currently in grade 5 and have benefited from an accelerated promotion from grade 1 to grade 2 in academic year 2021-2022 due to the COVID-19 will not be eligible to take part in the PaySAC assessment this year, as they would not have completed the 5 years of schooling. They will sit for PaySAC assessment in academic year 2026. Madam Speaker, With regard to the last part of the question, related to an elite system, I wish to inform the House that all leading nations have their own models of selection of their very best students from within their schooling system. I wish to inform the House that we should not vilify elitism as long as it is not at the expense of the well-being of our students. We need to nurture excellence, support high flyers, give them proper academic support, but at the same time, we should never forsake or neglect the well-being of those students who have learning difficulties or learning disabilities. I assure the House that this government will be fair and equitable to all our students. Thank you.
Thank you. We can't have another question. Time is up. Okay. Motion. Motion. Okay. Okay. There are two questions that have been withdrawn. B766, B767, and B728. 28. One moment. Can't be 28. I don't have 728. I don't know. All right. Yes.
That all the business on today's order paper be exempted from the provisions of paragraph 2 of standing order 10.
Motion seconded. Yes, Mr. Bhagwan. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of standing order 10. Those in favour say aye. Aye. Those against say no. The ayes have it.
Statements by ministers none for the bill first reading.
Madam Speaker, I move that the Criminal Appeal and Criminal Review Bill number 17 of 2025 be read a first time.
The motion needs to be seconded, yes? You second the motion.
Second reading.
Madam Speaker, I move that the Criminal Appeal and Criminal Review Bill number 17 of 2025 be read a second time. Madam Speaker, this bill may appear at first glance to be rather technical in nature, but it speaks in fact to something fundamental: the right to a fair trial, and more specifically, the right to a meaningful appeal. It reflects this government's commitment to ensure that our judicial system is further protected and improved. It is our goal to ensure that the delivery of justice in our courts becomes more coherent, accessible, and fair. Madam Speaker, let me begin by outlining the broad aims of this bill. At present, process governing appeals in criminal matters is fragmented and inconsistent. Procedures are scattered across the Criminal Appeal Act and its rules, the Courts Act, and the District and Intermediate Courts Criminal Jurisdiction Act. This has led to confusion for litigants, unnecessary procedural points being raised and argued, leading to delays in the administration of justice. This government's promise to make justice more accessible includes making it easier for laypersons to understand the law. True it is, we abide by the maxim that nul n'est censé ignorer la loi. This makes sense. We abide by the maxim, but you cannot have someone exonerated from legal obligation simply because it is argued that he or she did not know what the law said. It is a basic principle of the rule of law. But we cannot be blind to the fact that in this day and age, the combined volume of all applicable acts of parliament in a country like Mauritius is simply enormous. Even the most seasoned law practitioner cannot claim to know all of our laws. So the question arises, how can we be fair to our citizens? The least we can do, Madam Speaker, is to make it easier for people to get access to the law, that is, dans le concret and physically. This is why my office is launching in the coming weeks a website where all the updated statutes in force in Mauritius will be freely available without complex signing procedures and without uncertainties about past versions and amendments. The regulations will be uploaded shortly after, given the sheer number of regulations which we must admit evolve continuously. The next step, and which I readily admit is less straightforward, is to make our laws easier to understand. There are times when this will not be possible because of situations where legal drafting simply needs the technical language that allows precision and finality. But there are, on the other hand, many instances where we can be clearer, where procedures are complex, simply because of historical weight, rooted in reasons which are no longer relevant. In such situations, we must endeavor to make things simpler and more straightforward. The bill before the House today, Madam Speaker, aims to start this process for criminal law. It does so by consolidating all criminal appeal and review procedures under a single legislative framework. It simplifies the steps required to lodge and prosecute appeals, and it ensures uniformity of treatment, whether the appeal arises from the Supreme Court sitting in original jurisdiction or from subordinate courts. We are also introducing changes that will substantially improve the fairness of treatment of accused persons. For example, henceforth, there cannot be more than 28 days between the moment a person is found guilty of an offence and the delivery of his sentence by the court. We do not often realize, Madam Speaker, that there are today dozens of individuals who wait for months and, may I even dare to say, years in prison before learning about their sentence, with the risk that they could end up spending more time inside than what justice has decided or will decide for them. This is an intolerable situation which must be done away with forthwith. So, Madam Speaker, this bill may look to be simply a technical reform, but its effect will be felt. The more so when combined with all the other aspects of judicial reform which we intend to tackle, which is what we have promised in the government programme 2529, that is, to reinforce public trust in the justice system. Madam Speaker, allow me now to guide the House through the main elements of the bill. Part 1 deals with preliminary matters. Clause 3 imposes an important new obligation. All courts must now notify a convicted person of their right to appeal immediately after delivering judgment. It seems obvious, but this step is not currently mandatory, and its absence has at times led to injustice. Often, when someone is not represented at first instance by a lawyer, by the time that he processes the fact that he has been found guilty, he starts telling people around him about his conviction and why he disagrees with it, that he eventually learns that he can appeal and how he is to do that he travels to Port-Louis to try and meet counsel, where he will be told that he has got to get a copy of the judgment from the court in order for counsel to be able to advise him, and then for counsel to draft the grounds of appeal, not after having had to pay a fee to the registry of the court to obtain such a judgment, and that finally he needs to see an attorney to actually lodge the notice of appeal. The 21-day limit for appeals has, more often than not, already passed. We simply must make this process easier, and we start here by making sure he knows from day one that he can appeal. Part 2 of this bill covers appeals and reviews before the Court of Criminal Appeal. Clauses 4 and 5 establish its composition and jurisdiction. Here I should point out that the creation of a separate Court of Appeal in terms of composition and location is a reform that we are still working on, as set out in the government programme. I stress that this new bill will work seamlessly, whether in the new system to be proposed, or in the current situation where the Court of Criminal Appeal is composed of judges of our Supreme Court, where it also sits. Another important note here is that Clause 5.2 maintains that even acquittals following a jury verdict may be appealed by the DPP, but only in limited circumstances, where, for example, the verdict is unreasonable or a serious irregularity has tainted the trial. Clause 6 harmonizes and clarifies the procedure to appeal. The rule is now simple. Whether the appellant challenges conviction, sentence, or both, the deadline is 21 days from sentence. This replaces the outdated two-stage system before the assizes, where an accused party had to appeal against his conviction within 10 days of conviction and then await his sentence to challenge it, a source of confusion for lawyers and absurdity for all. This anachronism has to go too. Clause 9 introduces a clearer, better defined route for criminal reviews. The DPP may apply to the Court of Criminal Appeal for a review of an acquittal or dismissal where fresh and compelling evidence has come to light. A convicted person may similarly request a review, but here it is via the Human Rights Division of the National Human Rights Commission on the same grounds, that is, fresh and compelling evidence. This is a safeguard, not a second bite at the cherry. It is not a political tool, nor an appeal in disguise, but where evidence surfaces that is both new and probative, justice demands a mechanism for correction. Clause 9 provides for it. The role given now exclusively to the Human Rights Division reflects the fact that one cannot expect a convicted person in prison to go and obtain statement from witnesses or other forms of fresh evidence all by himself. He will therefore have the help of the National Human Rights Commission through its Human Rights Division. Part 3 mirrors the process of the Court of Criminal Appeal for appeals from subordinate courts to the Supreme Court in its appellate jurisdiction. Clauses 10 to 14 provide for composition, powers, procedures, and rules for such appeals. The goal, again, is uniformity. An important addition is the provision for a third judge to be appointed should the two judges, having heard the appeal, have opposing views on the outcome. This will ensure the avoidance of deadlocks, which too often these days just result in the decision being delayed until one side wears out. Part 4 addresses interim matters pending appeal: stay of proceedings, restitution of property, bail, custody of exhibits. Of note, however, is Clause 19, which rationalizes timelines for skeleton arguments: 30 days before hearing for appellants, 15 days for respondents, as opposed to 45 and 30 days respectively, now as the law stands. The new time frame is more realistic than the current regime, which is in fact rarely complied with, and it will improve preparedness and judicial efficiency. Part 5 lays out the determination of appeals and reviews. Clauses 20 to 33 set out the powers of the appellate court, including the power to substitute verdicts, order retrials, amend sentences, or correct serious irregularities. Clause 34 deals with outcomes of criminal reviews. The Court of Criminal Appeal may quash an acquittal or conviction and order retrial if it is satisfied that justice so requires and that a fair retrial is still possible. Clause 35 mandates credit for time spent in custody pending appeal or review, subject to specific rules. This codifies a principle already recognized in practice and jurisprudence. Part 6 includes miscellaneous provisions. Clause 36 allows for extensions of time on application made. Clause 37 enables the Chief Justice to grant legal aid even when no formal application is made, a small but important protection for unrepresented litigants. Clause 38 affirms the role of the DPP in representing the state in appeals and reviews. Clause 39, Madam Speaker, regulates ancillary matters like costs. Clause 40 empowers the Chief Justice to make rules for implementation. Clause 41 repeals the Criminal Appeal Act and the Criminal Appeal Rules of 1954, and Clause 42 introduces necessary amendments to 5 statutes, including the Children's Courts Act, the Courts Act, and the Protection of Human Rights Act. Madam Speaker, what this bill offers is not innovation for innovation's sake. It is a codification of best practice along with rationalization. And here I should stress that it is the fruit of careful consultation with the judiciary. This is the kind of legislative work that can make our system function more smoothly, more fairly, and with greater certainty. More such work will follow from my office, driven by the impetus of this government. Madam Speaker, before concluding, may I take this opportunity to say this. We have not included in this bill mandatory time limits for judgments to be handed down by the courts, but we are strongly considering this reform as well in the not-too-distant future in a separate and comprehensive piece of legislation. We have already started consultations on this issue, and we will discuss more, particularly with the judiciary. We will respect the views of all stakeholders and the constraints faced by them. But the time to make it happen will come, and we will not waver. Justice, Madam Speaker, cannot be achieved if the path to appeal is so entangled in procedural thicket that only the most sophisticated or well-represented litigants can find their way through. This bill is part of our duty as legislators to prune those thorns and light that path. This bill may not enthuse or incite great debate, but it is an important one nonetheless. I commend the bill to the House.
Thank you. Seconded. Seconded. Yes. Yes, Mr. Duval.
Thank you, Madam Speaker. Madam Speaker, I would have liked to rise from the opposition benches. I would have liked to rise from the opposition benches to fulfill our constitutional duty of rigorous oversight, but that is simply impossible given the indecent rush in which this bill has been thrust upon the House. The government has invoked Standing Order 65, urgent bills procedure, granting barely 3 days' notice and scheduling first, second, and third readings for today, even though, as you know, Standing Order 52-2, a long-standing norm, not the exception, requires 15 days' notice at least being given to members of Parliament and, of course, to civil society at large. And the statistics are stark, Madam Speaker. Out of the 19 bills introduced in this session, 17 bear a Prime Ministerial Certificate of Urgency. 8 of those, including this bill, have arrived with only 3 days' notice. Such a haste, Madam Speaker, denies the members of Parliament the time required to properly scrutinize legislation that will overhaul our entire criminal appellate framework. Worse, in fact, is the fact that there is only 2 of us here sitting on the opposition, and we are now to shoulder that burden. In fact, you will note 2 members of the opposition, the fewest since our independence in Poland. What is more, Madam Speaker, is that many on government side once condemned precisely this practice. The Deputy Prime Minister, without portfolio, the Honourable Béranger, when he sat in...
Will you sit down?
Is he raising a point of order? He's not speaking on the bill at all. You've given him the privilege of speaking number 2 in the place of the leader of the opposition, who is not even present. And you give him ground to say anything like that out of order.
All right. Please talk on the bill. We've got your first objection. Please speak on the bill.
Can I now not, Madam Speaker, bring in some ground, lay some ground foundation to the speech. I was saying the manner, this bill, you like it or not, has been brought to the House under Section Standing Order 65. I am talking about the manner in which this bill is being brought. And this was once said. First,
on a point of order.
Yes, yes.
If the honourable member wants to take a point of order, he is to. Don't interrupt me.
Doesn't even know what it is.
Don't interrupt me. Learn from what I'll say. Now, what I'm trying to say here is, if he wants to come up with a point of order, he is free to do so.
Then I'll give a ruling.
And obviously. But then again, if he's trying to use the back door, since he's used to using back doors, and he takes pleasure from using back doors, if he wants to do so by going to come and talk about a point of order, instead of going from a main subject of the debate, that is against standing orders. It's very simple. He is not being relevant. Now, the manner in which the bill is come can be the subject matter of a point of order. The leader of the opposition could have seen you this morning. He could have delegated someone to see you. They did not bother to do so. Now, if they haven't bothered to do so, and they are bright after the fact, we are not going to be listening here, wasting our time, and not even him talking about the debate.
Madam Speaker.
For God's sake.
This is not
You have to speak about the bill.
Madam Speaker.
Don't forget that I have been 15 years in this assembly. I am used to what you're saying. But you have to speak about the bill. You have to speak about the bill.
This very document has been laid on the table of the Assembly. What does it say? Certificate of urgency in respect of the criminal appeal and criminal review bill. This bill. So, Madam Speaker, since when can I not talk about the manner in which a bill is brought to the House? It is entirely relevant. Entirely relevant. And it was being said, it is not a point of order what you have taken. Under which standing order? Not at all. Do not try to intimidate me. I will do my speech. Madam Speaker. It will.
You have to speak about the bill, otherwise I will suspend the sitting.
It was once said in the House that first, second and third readings being brought is not acceptable.
Stop reading.
And that is not how good parliamentary work.
Standing orders allow certificates of urgency.
I am talking precisely about that. I am not raising a point of order. I am merely explaining how this bill is being brought into the House. It is about the bill. Madam Speaker,
Now come on the,
it sounds
on the bill
fishy,
itself.
to say the
Now you
least.
come on the bill itself.
In fact, this government, I've said what I had to say. I will say more outside if I'm being precluded from saying it inside. Now, expert voices, Madam Speaker, have likewise been excluded. The Law Reform Commission, the Mauritius Bar Council, the Mauritius Law Society have not been consulted, nor have been had the courtesy of being sent a copy of this legislation, of this bill. And that is very important. And therefore, there has been no meaningful opportunity for them to offer their expertise and to pronounce on the bill. By compressing the debate, like I said, it's not the first time. The exception has become the rule, but by compressing this debate into a 3-day sprint, the government has deprived Parliament of the independent insight needed to grasp serious constitutional and procedural changes which are at stake. I will call it legislative ambush. The bill, Madam Speaker.
Now, come to the bill.
Yes, it is all about the bill. It is all about the bill. Whether I bring it without consultation, the manner of bringing the bill is all about the bill. I'm not talking about making political arguments here. I'm talking about the respect that we've shown to this House. One of the cornerstones, and I will say, Madam Speaker, and that proves the point I have to say about the bill. In fact, I don't have that much to say about the bill, because we have been given so little time.
You have nothing to say.
3 days. One of the cornerstones of our legal system And especially,
Rodrigues, please sit.
I'm talking about the various provisions.
I won't. No, you're not. You're not. We will have to make a decision here. You have a bill. As I say, I've been here 15 years. We've had several bills like this, which come on one day, next day. If you cannot talk about the bill, you've made your point about why you cannot, then we will stop here. Somebody else will speak. I've read the bill. I've also got it last minute. I'm also a lawyer like you. Now, either you can speak about the substance of the bill, or you feel that you haven't been given time and then you give up. You've made your point already.
That would have been, I think, what many here would have wanted. But I will speak about the bill. One of the cornerstones of our legal system, especially of criminal legislation, is the principle, Madam Speaker, of legal certainty. That is, that the need for the legislature to be abundantly clear in the drafting of the law to avoid any ambiguity or confusion in the interpretation of law by the court. This bill, in my opinion, will affect one of the most fundamental rights of the citizen, the right of appeal, in its lack of clarity in certain aspects. And I will explain. And I find this even more worrying, that important rights and principles which are beneficial to accused parties under the current legislation are being done away with. Let me come to the specific provisions. Under Section 11(2)(a), the right of appeal shall now lie where one is sentenced to undergo penal servitude or imprisonment, with or without a fine, or to pay a fine of 1,000 rupees or more. Therefore, as it is presently, when the fine is less than 1,000, you do not have the right of appeal. But penal servitude, imprisonment, and fines are not the only existing sentences which the court can impose. What about suspended sentences and community service orders under the Community Service Order Act? What about conditional and absolute discharge under the Criminal Procedure Act? And this, I believe, is for the legislator to clarify. Are these now also going to fall under Section 11(2)(a)? It is for, I hope, the Attorney General to explain. It appears, therefore, Madam Speaker, that those people shall therefore be deprived of the right to appeal. In any case, the object of the bill was to clarify, and it has not done so. Under Section 22, a citizen shall henceforth be deprived of his right of appeal against a judgment where there is a variance between the information and the evidence, unless he has raised the point before the trial court. But the reality, Madam Speaker, is that in many cases, accused parties are simply not represented by counsel at trial stage, whether it is for lack of financial resources or for other reasons. But this is the reality. And of course, those persons cannot be expected to take objections in law in the course of their trial. So this section will essentially deprive those persons of the protection against improprieties in their trial, and yet this protection under the current law exists. I'd like to quote the case of Liu versus the State, 2021 Supreme Court case. The accused was unrepresented at trial and found guilty. The appellate jurisdiction of the Supreme Court quashed the conviction precisely on the ground that there was variance between the information and the evidence, which point, you will no doubt understand, was raised only at appeal stage. I hope that the Attorney General can clarify whether now it will be the case for those persons who were in absconsily and could not, therefore, raise that point in law. Section 9 and Section 34, Madam Speaker, puts une épée d'Armoclès on citizens by giving the right to the Director of Public Prosecution to apply for review of sound appeal judgment and to have a retrial of a case which was properly tried where there is evidence according that comes to light. This is contrary to the very well settled principle of autrefois acquis
Keep an eye on
and
the
certainty, which guarantee that once a person has been acquitted, he should be protected from subsequent prosecution for the same facts. Moreover, Madam Speaker, it appears that there is no time limit under the Act for the DPP to apply for the said review. This will result in acquitted individual to suffer the lifelong stress and anxiety of having their case reopened because of the lack, precisely, of certainty. There are positive, of course, provisions in this bill. The fact that the court must inform every convicted person of their right to appeal. The fact that now there is a clear set of days between the time the conviction is handed and the sentence must be handed of 28 days. And there is also the automatic, that time spent in custody shall automatically be credited against the final sentence. Madam Speaker, to conclude, I will conclude with these remarks. No meaningful debate, in my opinion, can take place when we sideline the very stakeholders whose expertise is indispensable. The Law Reform Commission, the Mauritius Bar Council, the Mauritius Law Society are but a few of those who would have had they been given proper notice, something to say about this bill. I'll quote the Deputy Prime Minister again, who said at the time, allons tirer une leçon de tout cela, saying about the first, second and third reading being brought on the same day. À l'avenir, pour les autres projets de loi, selon lesquels il faudrait, dès qu'ils sont prêts, les circuler pour qu'on puisse avoir amplement le temps de les considérer à tête reposée. Well, perhaps, Madam Speaker, it is indeed time for some of us to go and se reposer à la maison.
That was very, very bad. Very, very nasty. Very nasty. Shall we break so that we can all get a... Or you want one more speech? One more speech? Okay, one more speech then, because I wanted to break at 5. All right, let's have Mr. Seaburn. Mr. Seaburn, please.
Thank you, Madam Speaker. Madam Speaker, I rise in support of the proposed Criminal Appeal and Criminal Review Bill, which is a reaffirmation of our rule of law. The bill comes with a view to bring clarity and certainty in this area of the law, so as to simplify the procedures in a deliberate and thoughtful consolidated legislation for appeal and review cases across all levels of our judiciary. Madam the Speaker, unfortunately, the honourable member of the opposition stated that this bill has been brought in only a few days. This is not correct, as there was already an indication in the announcement of our government program 2025-2029 that these legislations are in the pipeline. Madam the Speaker, under the current system, the criminal appeals and criminal review cases are governed by a scattered set of statutes, case law, and procedural rules. The courts are operating under different routes of appeal, under different legislations, which has left the people, especially the vulnerable ones, who wishes to challenge a conviction or sentence, often confused. This lack of uniformity risks undermining the very principles upon which our justice system is built, including fairness, accessibility, and equal treatment under the law. This bill is a transformative step forward of how justice is administered in our country. Madam the Speaker, as the Honourable Attorney General, at the very outset of his speech for this bill, said that this will promote fair trial. This bill unifies the appeal rights of all appeal cases in criminal matters that are made from the final decision of the Supreme Court and from the final decision of the District Court, the Intermediate Court, and the Children's Court in a single and coherent legislation. In doing so, the bill will strengthen legal certainty and will protect the rights of all parties involved in criminal proceedings. Madam the Speaker, the bill clearly imposes an obligation on any court Madam the Speaker, the bill clearly imposes an obligation on any court.
Allow the member to speak. Yes, allow the member to speak. Carry on.
Madam the Speaker, the bill clearly imposes an obligation on any court to immediately notify the convicted person of his right to appeal or the procedure to make an application to review the proceedings of the Supreme Court before the Court of Criminal Appeal. Part 1 of the bill deals with the preliminary matters, including the short title, the interpretation, and the notification of the right to appeal. Part 2 of the bill outlines the composition, the jurisdiction, and the powers of the Court of Criminal Appeal, and further outlines the procedures, the proceedings, and the notice required to resist the appeal before the Criminal Court of Appeal. Section 10 of the bill provides that an appeal before the appellate criminal jurisdiction of the Supreme Court shall be heard by at least 2 judges, and further provides that the Chief Justice may, upon receipt of an application, direct more than 2 judges to hear the appeal, having regard to the magnitude of the case and the importance of the question of law and the importance of the question of facts involved. Section 11 of the bill provides that the Supreme Court shall have unlimited jurisdiction and powers to hear and determine appeal by a person against his conviction or sentence, or hear the appeal by the DPP against any dismissal of a charge or conviction or sentence imposed on a person from the final decision of the subordinate court. Madam the Speaker, Section 12 and Section 14 of the bill deals with the procedure to appeal and the appeal proceedings before the Supreme Court. Section 13 provides that a party upon whom a notice of appeal is served, that party may resist the appeal before the Supreme Court by filing a notice of his intention to resist the appeal within a maximum period of 28 days. Part 4 of the bill deals with the matters pending before the Court of Criminal Appeal as provided under Section 15 and Section 16 with the stay of proceedings and the restitution of property pending trial. Section 17 provides that where a person who has been convicted and sentenced gives notice of appeal to the court before which he is convicted and has been refused bail pending appeal, may apply to the appellate jurisdiction of the court to be admitted to bail pending the determination of his appeal. Section 18 and Section 19 of the bill deals with the custody of exhibits and documents and the filing of skeleton arguments and submissions pending the criminal appeal. Madam the Speaker, Section 20 to Section 33 under Part 5 of the bill deals with the determination of the general powers of the appellate court, including issues relating to miscarriage of justice, defect in information, warrant and summons, omission and mistake, and further issues regarding evidence, irregularity and lack of records, improper convictions, and acquittal on account of insanity, and also deals with the bar to subsequent prosecution and dismissal of a charge and other powers of the Supreme Court. Section 34 of the bill provides a specific general powers to the Court of Criminal Appeal on review to call fresh and compelling evidence that is likely to quash the acquittal or conviction by or order that person to be retried for the offense with which he was originally charged. The Honorable Attorney General rightly said earlier that this is not a political tool, but rather a safeguard. Madam the Speaker, Section 36 of the bill provides that where a convicted person has not been notified of his right to appeal, may have good cause to appeal, to apply for an extension of time to the Court of Criminal Appeal. Section 37 of the bill emphasizes on access to justice and empowers the master and registrar to report to the Chief Justice where legal aid should be granted for the purpose of an appeal or review, although no applications were made. Section 38 of the bill provides that the DPP shall appear for the state on every appeal to the appellate court unless it is a private prosecution, and appear before the Court of Criminal Review on every application for review. And Section 39 of the bill goes on to say that no costs shall be allowed on either side on hearing any appeal or review by the Court of Criminal Appeal under this Act. Section 40 of the bill empowers the Chief Justice to make such rules as may be necessary for the purpose of this Act, thus upholding a fundamental principle of the rule of law. Madam the Speaker, the bill further intends to repeal the Criminal Appeal Act 1954 and revoke the criminal appeal rules as specified in Section 41 of the bill. The bill addresses a major void in this area of the law by imposing an obligation on any court to pass sentence on a convicted person within a maximum period of 28 days and not later. Madam the Speaker, the bill proposes to amend Section 11 of the Children's Court Act under Section 42, where now an appeal against an order or the final judgment of a magistrate of the Criminal Division of the Children's Court will be made to the Supreme Court in accordance with the Criminal Appeal and Criminal Review Act. Clause 42 of the bill also proposes to repeal Section 69 and 70 of the Courts Act and provides simplified provisions under this bill to deal with criminal appeal cases. The bill further proposes under Clause 42 to amend Section 132A of the Criminal Procedure Act, which deals with hearing on sentence, where now, after convicting an accused, the court shall have, having regard given an opportunity to the accused to adduce evidence in mitigation, and after hearing such other matters that is relevant to the facts and circumstances of the offense, impose the sentence on the accused within 14 days. Madam the Speaker, the bill brings further amendments to the criminal jurisdiction of the District and Intermediate Courts Act by repealing the entire provisions under Section 92 to Section 100 of the Act, which has been a complex and confusing area of the law. This bill has now simplified the procedures for a person who has been charged with an offense, for the prosecution, for the court, and for the legal professionals. As Jeremy Bentham, a great English philosopher who continuously advocated for simplified legal system, says, "A law that is not clear is no law at all." Madam the Speaker, in fact, any person who cannot easily understand their right to appeal, or when the process to seek redress is unnecessarily complex or inconsistent, it is the integrity of our entire justice system that is called into question. As such, complexity and inconsistent outcomes causes delays and uncertainty, not only for the appellants, but also for the victims and the law professionals. It is unacceptable that in matters of such gravity, where the liberty and rights of individuals are at stake, and that our justice system would tolerate ambiguity in the process. Madam the Speaker, the bill ensures that once a final decision has been delivered by the Supreme Court, District Court, Intermediate Court, or Children's Court, the party will have a clearly defined, legally consistent pathway for appeal or review, which will ensure confidence and fairness against arbitrary outcomes. The bill further reinforces the constitutional right of individuals under Section 10 of our Constitution, which guarantees a fair trial. The bill supports the independence of the judiciary by offering a clear and predictable framework for criminal appeal cases and further protects the most vulnerable ones. Madam the Speaker, the bill also reflects our international obligations under human rights instruments to which Mauritius is a party, including International Covenant on Civil and Political Rights, which affirms the right of every person convicted of a crime to have their conviction and sentence reviewed by a higher tribunal. Hence, Clause 42 of the bill ensures that the proposed Criminal Appeal and Criminal Review Act 2025 will continue to provide access to a convicted person or his representative to make application to the Human Rights Division for inquiry to be conducted in cases where there is sufficient fresh and compelling evidence that will satisfy the requirement to carry out investigation. Madam the Speaker, the judiciary, as we know, is a cornerstone of our democratic society. By simplifying the criminal appeal and review cases, we are reducing unnecessary delays. We are alleviating the burden of our courts. We are ensuring that judicial time and resources are focused on the substance of justice. Today, this House is being asked not only to pass another legislation, but rather to reshape the very system of justice for our country. We are being asked to bring clarity in an area of law that is complex and confusing for our system and for our people. We are being asked to ensure that the pathway to justice is a clear road that is accessible to all, regardless of status, regardless of age, and regardless of means. Madam the Speaker, before I conclude, I would like to thank the Honorable Attorney General and the State Law Office team for coming forward with this progressive piece of legislation that will reshape our criminal appeal and review cases, thus increasing public confidence in our institution. I therefore urge all the party members to come together to give full support to this bill as custodians of justice and deliver a framework that will serve the law and the people it is designed to protect. We are sending a strong message to the people of Mauritius that we believe in a justice system that is transparent, fair, and equal for all, thus upholding a fundamental principle of the law as one says, justice must not only be done, but it must be seen to be done for everyone, and the bill aims to achieve that. Madam the Speaker, with these words, I commend it to the House.
Thank you. Yes, I think we have time for you, Honourable Levy.
Thank you. Thank you, Madam Speaker. Madam Speaker, first of all, I'm just flabbergasted by this despicable performance from this honourable member from the opposition side. Completely out of subject. He couldn't understand what the particular clauses of this bill is all about. And the more so, he's just cut off from the reality, from the debates. Debates with regards to criminal appeal, criminal review, dates way back in 2012. He's talking about the Law Reform Commission, way back when Guy Olivry, the then Guy Olivry, Queen's Counsel, was the chairman of the Law Reform Commission. They already worked on it because they got it from a green paper that was presented by the then Labour government when Lord Mackay of Clashford made a comprehensive report as how we have to move on to reform the judiciary. So he's completely cut off from debates, from reality, and it is not with this certificate of urgency that debates have started on this particular bill with regards to review and also with regards to access to justice. And what surprises me, Madam Speaker, is that the lack of decorum, lack of elegance from a member. But what can we expect from somebody who came through the back door and entered in the previous government? Through the back door, Madam Speaker, he became Speaker. Because the previous government, for the past 10 years, they got all these reports already worked in their drawers. They couldn't do a single reform with regards to judiciary or the judicial system. And this government, since January 2025, under the able capacity of the Attorney General, who is rising above politics with regards to all these amendments. There is nothing to do with petty politics, these amendments. This is access to justice. He couldn't understand, and lack of decorum, he's not even here to listen to the debates. This is a lack of courtesy, lack of manner, and I'm very sad that this honourable member is a lawyer. Either he understands the bill, or he pretends not to understand what the bill is all about. But if he doesn't understand that there is a problem with regards to his capacity as a lawyer, as a barrister, because we have to rise above party politics with regards to this particular bill, Madam Speaker. And I'm also...
Speak
yes.
on the bill now.
Yes. Madam Speaker, after the legal aid and legal assistance bill that was enacted, which is now an act, this is another piece of legislation that is another milestone to render justice more accessible to our people. And the Criminal Appeal and Criminal Review Bill is a timely and essential piece of legislation aimed at reforming and unifying appellate procedures in criminal matters. The Honourable Attorney General rightly put it, this bill replaces a fragmented and inconsistent legal framework with a single coherent system designed to ensure fairness, legal certainty, and access to justice. This is a clear signal as to the commitment of this government to come with institutional reform, be it through the judiciary, responsiveness to long-standing challenges, and delivery of justice as a public good. This current system, the way appeal are being done, Madam Speaker, the appeal procedures are dispersed across outdated and inconsistent enactments. The Attorney General pointed out the Criminal Appeal Act, the Criminal Appeal Rules 1954, the Court Act, the District and Intermediate Courts Criminal Jurisdiction Act, the Criminal Procedure Act, and the Children's Court Act 2020. This scattering of rules has created uncertainty, procedural inefficiencies, and at times impeded on the administration of justice. This bill brings a sort of a consolidation of what we law practitioners and the public at large desire. Madam Speaker, with regard to the work of law practitioners, it is indeed something that will render justice and also deliver justice and give advice to clients more efficiently, because first and foremost, at clause 42, subsection 3, this bill introduces a statutory deadline by amending section 132A of the Criminal Procedure Act. It provides, Madam Speaker, the court now must impose sentence within 14 days of conviction. This fills a long-standing gap in our criminal process. Previously, there was no statutory framework for sentencing past conviction, leading to prolonged uncertainty and delay in initiating appeals. There is also, secondly, Madam Speaker, for the first time, this bill introduces a uniform appellate process with standardized timelines for filing notices, skeleton arguments, and replies. The bill includes deadlines that will reduce abuse of adjournments and promote discipline among both parties in the courts. And timely access to records, Madam Speaker, with the clear timelines being provided. Now it is also upon the court registry to furnish complete appeal records within a fixed time, because it is clearly elaborated in this particular legislation that there are timelines to be respected. So it will facilitate jobs of the legal professionals, but also the public at large, Madam Speaker. And clause 3 of this bill, Madam Speaker, the statutory duty to notify right of appeal. This is something, for the first time again, very innovative approach in our law. Every subordinate court will be required now, Madam Speaker, to notify a convicted person of their right to appeal. This is a transformative procedural safeguard, and we are not far from other countries that are embarking on such reforms with regards to criminal procedure. In India, for example, they are trying to amend the Code of Criminal Procedure in the same manner that we are proceeding. In the UK, they are also debating in their 2025 law reform with regards to procedures, with regards to criminal appeal. So, Madam Speaker, another milestone is clause 9. Clause 9, review of convictions and acquittals. Clause 9 introduces a long-needed mechanism, Madam Speaker, for the review of criminal cases after finality. Until now, Mauritius had no statutory provision allowing for the reopening of cases where new and compelling evidence emerges. The only recourse was presidential pardon. This bill introduces a robust, judicially supervised review process. Post-conviction reviews may be initiated by the accused. Post-acquittal reviews may be brought by the DPP if the acquittal is tainted. This aligns, Madam Speaker, our country with Article 4, subsection 2 of Protocol 7 of the European Convention on the Human Rights, which permits the reopening of criminal proceedings if there is new or newly discovered evidence, or if there has been fundamental defect in the proceedings. And this is what the Law Reform Commission said in 2012 with regards to miscarriage of justice following acquittals or convictions. And also, another milestone of this bill, Madam Speaker. We spoke a couple of weeks back with regards to legal aid. Here in clause 37, Madam Speaker, legal aid without application. One of the most commendable features is this clause 37, Madam Speaker, empowering the Master and Registrar to refer deserving cases for legal aid to the Chief Justice, even if no application has been made. This provision realizes the opinion given by the Law Reform Commission with regard to the paper on legal aid reform that complements the Legal Aid and Legal Assistance Bill 2025, which was very recently debated. And unfortunately, again, Honorable Adrien Duval, he was not present when we were debating about it. He pointed out to legal aid, this is already in our law now. Madam Speaker, we must realize that with all these amendments, we are complying with what the UN Committee Against Torture, in its concluding observation made in April 2025, following the consideration of the 5th periodic report. That is, we are consolidating our criminal justice system. This bill responds directly to those recommendations by addressing procedural gaps and enhancing appeal and review rights. And, Madam Speaker, I will not go into the comparative studies that are being conducted throughout the world. New Zealand is doing it through the streamlining of their criminal procedures. The UK through the 2025 Law Reform Commission review, recommending widening of access to criminal review. In Canada, they are doing it following the famous case of R against Jordan. So, in that respect, Madam Speaker, Mauritius is not merely following. We are acting in solidarity with other democracies, tackling the same systemic issues through principle reform. And to conclude, Madam Speaker, I would quote Lord Atkin. Lord Atkin said, "Finality is a good thing, but justice is a better." This is all about justice, and I commend this bill to the House. Thank you, Madam Speaker.
I think now we can take a break. 30 minutes, more or less.